Welcome back. It's now 11 minutes away from 7 o'clock, and as promised before the break, we're going to be sitting down to talk about the Magna Carta and its influence on human rights in Belize. And joining us for this conversation, we have the head of the Open Campus for the University of the West Indies in Belize, Jane Bennett, and we also have a senior lecturer from UWI, St. Augustine Campus in Trinidad, Dr. Hamid Gainey. Good morning and welcome to the show.
Thank you.
Good morning. And thank you guys for having us here.
Now, let's do a little backdrop first. How did this idea come to actually discuss the Magna Carta?
Well, essentially, the Magna Carta is going to be 800 years old this year on the 15th of June. And there is a Magna Carta 800th anniversary committee in the United Kingdom, led by Sir Robert Worcester. They put out a number of calls for research grants, applications for research grants during last year. And my research unit in the Faculty of Social Sciences at UWI, the Constitutional Affairs and Parliamentary Studies Unit, CAPSU, we put in an application for one of the research grants. The deadline was August 30th last year. And by the 1st of October, we were advised that our application was successful. So that then opened the door to a number of activities. Now, the proposal that I had put in related to having a series of seminars and lectures around the Commonwealth Caribbean to the extent that what we were applying for could afford it. So we've chosen a number of areas to go, and the formal launch was on October 18th last year in Trinidad at the St. Augustine campus of UWI. And Sir Robert Worcester from the Magna Carta 800th Anniversary Committee came to Trinidad for the launch. And then we scheduled a number of lectures and seminars to start early in the new year, so that we had the first one in Dominica on the 9th of January, the second one in St. Vincent and the Grenadines on the 17th of January, and this is going to be the third one today, later this morning, on the 29th of January. After today, we have Montego Bay on the 2nd of February, the Mona campus in Kingston on the 4th of February, the St. Lucia Open Campus site on the 11th of February, the Cave Hill campus on the 18th of February, and then St. Kitts Nevis is confirmed for the 20th of March, and the Cayman Islands will tentatively, it has been said, for the 18th of March, subject to final confirmation. So that will more or less conclude the sweep that we've had across the Commonwealth Caribbean. We cannot go to all of the territories because the budget is configured in a particular way. But we have decided to approach the Open Campus of UWI as the entity through which this can operate, seeing that the Open Campus of UWI has this reach to 16 areas throughout the Commonwealth Caribbean.
Now, a law or a set of laws that were created 800 years ago, why is that significant to us now?
Well, the significance lies largely in the philosophical basis for many of the things that we take for granted today. Things like habeas corpus or trial by jury or some of those other legal principles. We may often just take it for granted, but not have a sense of where this has come from. And largely speaking, those two items have come from the Magna Carta. So it is 800 years old. It has had an influence on some of the legal principles that have come into our legal systems in the Commonwealth Caribbean and in other parts of the Commonwealth and other parts of the world. But we perhaps have taken it for granted. There would be a relatively low level of consciousness on the Magna Carta. Not many people would know about it. You just ask them about it, they wouldn't be able to, you may have a minuscule number of persons may be able to give you an immediate response about their knowledge of it, and there are others who would not know about it and would have to go search it up. But once you go searching it up, then you start to encounter all of these other features. So to a large extent, this exercise also raises the level of awareness about the Magna Carta in relation to human rights and constitutional development in the Commonwealth Caribbean.
One further question, please, because very often we talk about laws being antiquated and need for revision. Is that something also has the Magna Carta from its original conception evolved with time as well? And besides those particular issues that you spoke about being philosophically remnants in the laws as we know them today, are there other significant portions that have evolved and remained with us?
Well, there was 63 sections, and some of them relate back to that period when the king and his barons came together. And largely speaking, the significance of the Magna Carta is the ability to curb the powers of the king. And therefore, to the extent that you are curbing powers, creates a situation in which that phenomenon in itself is a very political phenomenon in respect of constitution making and so on. So there may be things in the Magna Carta that no longer have relevance today because they were peculiar to that age. Yes. But there are other principles and philosophical issues that have survived the passage of time that have informed what has been put into many constitutions rather than being the exact wording that will go into the Constitution.
Yeah, I want to bring it over to Ms. Jane for a bit just to talk about making use of this opportunity with Dr. Ghani here and the panel that you've gotten together and who you've invited.
Okay. So thank you first of all again for having us on the show. I want to welcome my colleague Dr. Hamid Ghani again to Belize. He's no stranger here, and we always bring him here for significant events actually. Marlene, to answer your question, as Dr. Ghani said, it's an opportunity to make that link between what we see today in our judicial system as well as the human rights issues that we're facing as a country, and how this started way back when people decided in their time that we need to be respected, we have rights, and we don't want the king or whoever in power to infringe on those rights. And so that was the whole evolution 800 years ago, where people started standing up for their rights. In putting together this distinguished lecture and panel for today, I spoke to colleagues, others in the history and judicial area to pinpoint for me somebody who could deliver the lecture, would have a wide enough knowledge, and also could interact as a panel. The target audience are our tertiary level students, and I have to say there's an avalanche coming from the University of Belize. So it would be UB students, St. John's College, Junior College, and Wesley Junior College. That would be the target audience for today. And of course, members of the public, other attorneys and historians who want to come by are welcome. We'll try to accommodate everyone as best as we can. And so there were actually two of the folks listed here who had been identified for the distinguished lecture, but it was first come, first served because I had to pin that person down first. So Mr. Dickie Bradley agreed unhesitatingly to do that for us. And then the other lineup is Mr. Michael Young, Ms. Cynthia Pitts, both attorneys at law, Mr. Joseph Sampson, who is a lecturer at the University of Belize, and there were a couple other people who could not be on the panel. We wanted like 4 or 5 people. So I think it would be quite an interesting and informative discussion for our students and others who have an interest in knowing these things. But as Dr. Ghani said, we're here today and we need to know where it came from, the whole concept of freedoms and rights and so on. So that's the whole idea. And I'm hoping, though, that this is the beginning of a dialogue within our classrooms, within the wider society, that people can make those linkages. We always say you kind of don't know who you are, in a sense, unless you know where you came from. And that, I think, reverberates to all of our lives. It's not just one aspect of maybe your ethnicity or your race, but it's also these other important aspects.
One question that begs asking at the very beginning also is, generally laws are created out of a particular need. What led to the Magna Carta's creation in the first place? What was the uprising that brought it about?
Well, I think this is largely, it's emerged largely as an elite type confrontation between the king and his barons. So it was to a large extent an elite confrontation, if we are to take it in its strict format of the king facing the barons and agreeing to curb many of his powers and have it on a document and seal the document as they used to do in those days, so that it was sealed on the 15th of June 1215. It will be 800 years old on the 15th of June this year. A document that has survived that length of time, whose principles have been infused into a number of other significant documents in many other countries that have to do with the exercise of powers, the recognition of rights and freedoms, and so on. So to that extent, it has its own historical value. But I think that the real issue here would have been the confrontation between the king and his barons on this issue of curbing the powers of the king and setting up certain principles that, you know, if you're going to try somebody, well, you have to have a trial by their peers or a jury, or, you know, you just can't take people off to prison and they just disappear like that. You don't need the habeas corpus principles and so on. So these kinds of things would have been what they would have discussed. So what may have started as an elite type confrontation over the centuries has been able to spread its way into various other constitutional documents. And while there may have been periods of history that were not particularly reflective of Magna Carta, in the end, the principles of Magna Carta were the ones that came through at the end of the day.
Now, I like what you're saying. I think that's an important point to look at. The reason as to why the Magna Carta was first created. And you keep on using the specific term, it's realizing that there needed to be a curb of power. And it's still something very relevant to what we speak about today. Anytime there is an issue, whether political or even within other realms. Now, we can understand the influence in terms of the foundation of the Magna Carta in constitutional law and the basic tenets of human rights. But let's talk about the influence. How much has it influenced this particular region specifically?
Well, I think that many of the countries in the Commonwealth Caribbean have English common law as the basis of their legal system. And to the extent that Magna Carta constitutes a significant chunk of English common law, that would be one of the areas where you will find great influence. With the development of human rights over a period of time, one would have found a number of human rights issues arising that are reflective of curbing the powers of the state in respect of the individual. So you may find that in a situation in the Commonwealth Caribbean where you have 12 independent countries, 11 of them use a particular model that might resemble the European Convention on Human Rights of 1950. And Trinidad and Tobago is the only one that has a model based on the Canadian Bill of Rights of 1960. So in that context, the fundamental issue is, as with all human rights doctrines, is that you're attempting to curb the powers of the state in relation to the citizen. And this is where we can see some of the philosophy of the Magna Carta coming through. We could get into all kinds of specific rights and that kind of thing, and that will be perhaps part of the documentation and so on, and a little too, you know, detailed to get into that on your morning television show. but merely to say that you know, the rights and freedoms that we have are all given, and then there are exceptions that certain things, so that in the European Convention model you're really denying infringements, but you're allowing certain infringements if there is due process of law, that kind. So you have a denial of an infringement and then a permission, all wrapped into the Bill of Rights. In Trinidad and Tobago, the rights and freedoms are stated up front in absolute terms, as is in the Canadian Bill of Rights 1960, and then you have the exceptions stated afterwards, exceptions for existing law or what have you, so that you have exceptions that are stated afterwards. So again, it's like you give with one hand, but you take away little pieces with the other hand where the state is concerned.
And this is what I really find interesting as well, because understanding the impact or the influence that the Magna Carta has had both in human rights and constitutional law, especially in the Caribbean, we seem to still have some issues in terms of the total acceptance of human rights. We can understand constitutional law because it's a law. It's easier to say this has been handed down to us, we must adhere to this. But the aspect of human rights is still a challenge. What would you say accounts for that?
Well, you could have things laid out in a document, but these all have to be handled by institutions, populated by individuals who will get into various positions. So, to a large extent, the way in which individuals discharge their powers while in office is really where the protection will come from in respect of a number of these things. So I'm not casting aspersions on anybody who has held office. I'm just saying that you can make these laws, but at the same time, their enforcement and the extent to which they are upheld, these are issues that depend very much on the individuals who hold office, as opposed to the laws themselves, which speak to their own restrictions, their own powers, their own effect, what have you. But the individuals who handle the offices are the ones really who, at the end of the day, have to be the guardians of these things. So that, to a large extent, is, this may be man-made law, but how mankind handles it in terms of discharging powers is a completely different story.
And I think that answers your question, Marlene, because as you go from territory to territory, even though you can see these blatant kind of disrespect and violation of human rights, and then again in another territory it might be a little better. So it deviates, and it depends really on who's applying those laws and who's upholding the human rights.
Now, one question that came to mind as you were talking just now for me has to do with, we talk about human rights and we signed on to different conventions, but when you get down to the details and the interpretations of what those mean, that's where the difficulty lies, because it's such a broad sweep when you just say human rights. In defining or even signing on to different conventions, we have problems with implementation on the ground. Is it a political, a lack of political will to actually feel the full impact of the conventions, for example? Or is it just that getting people on the ground to live by those tenets when they're perhaps hard to detail is the difficulty, the real difficulty, and not necessarily a legal difficulty, but the implementation in a day-to-day existence?
Well, when many of these constitutions in the Commonwealth Caribbean were being formulated, you didn't have the kind of political consciousness and awareness that you have today. So that in many respects, these constitutions came out of discussions that may have been held locally, but the extent to which the local population was deeply involved in that awareness of these things is very different to what you have today. So if you are making a constitution, or you're amending a constitution, or you're doing things today, the public involvement is far greater today than it was maybe 30, 40, 50 years ago, depending on when the constitution was brought in, whichever territory we're talking about. So that I think that things like human rights and things like constitutional, new constitutional design and constitutional reform and changes to the constitution attracts a very, very significant level of public participation today as opposed to before. So that some of these things may have come into being in our constitutions across the region as a consequence of the political movement of the time to move towards independence. And independence was perhaps the large or the big goal that one was trying to attain at that time. Today, it's a post-independence environment, so now we're talking about protection of rights and freedoms, and even in some cases people talk about constitutional reform and making changes and that kind of thing. And therefore you get a different kind of engagement. We're not in a move to get independence now, we're in a move to protect what we have and try to improve on it. And that's a completely different psyche to what may have been the case 30, 40 years ago.
And the whole, when you look at, for example, because the US also, constitution and laws were also shaped by the Magna Carta, you have the Bill of Rights, for example, which clearly delineates certain things. But you don't see that necessarily being a major part of other constitutional developments. Why not?
Well, the Bill of Rights in the United States Constitution came around 1795, and the first 10 amendments to the Constitution, and that is called the Bill of Rights. So that there was a period of time between when the Constitution came into being and when the Bill of Rights was made, when there was no Bill of Rights. So that over the years it has largely evolved in a particular way. But the American system is very different because we're talking about a system with a presidency with fixed dates and a Congress, and the president doesn't require a majority in Congress to be in office, as we see now quite graphically. But there are fundamental differences, and I'll give you an example. If you appear before a congressional committee to give evidence, a committee of the legislature, you swear an oath to tell the truth, and if you're lying, you can be charged for misleading a congressional committee. If you go before a committee in a parliamentary system, you swear an oath. You may not be called upon to swear an oath in some instances, but what you get are the rights and privileges of the parliament. So you're protected by parliamentary privilege in what you do. So that it's a completely different type of engagement. It's a completely different political system. Being protected by parliamentary privilege, going before a committee in a Westminster-style parliament, is very different from swearing an oath before a Washington-style legislature, where you could be charged for misleading the committee if you say something different. So it's two completely different political systems that we're talking about. However, the Magna Carta does have its shadow casting in various areas, but how you actually crafted your constitution and what you eventually made for your constitution is a completely different situation. So we have to understand that there are differences of political system if we use the American model when compared with the Westminster Whitehall model that we have in the Commonwealth Caribbean.
Why is there such a great resistance to do any kind of constitutional reform? Because whenever we start looking at that, people start getting really nervous. The political powers that be, there's a great tug of war. And why is there such a great resistance if it's a natural thing for the evolution to take place, especially when you talk about expanding human rights and getting it right?
Well, I think that once you're changing the rules of the game, there will always be concern. I mean, the intentions could be very good intentions, very noble intentions, very logical intentions, but there are others who always have a suspicion of what a political directorate or political operatives may be attempting to do. Some constitutions require high levels of consensus, special majorities, which are likely to cut across the political aisle, and if you get that, then there will be a lower level of anxiety. If it is that you're not getting that and there are other things at work, then there are higher levels of anxiety from those who do not hold power, looking at what those who are in power are doing, and that is natural across many constitutional systems. So that the reason for special majorities when you're changing the constitution is to get the level of consensus. In some other countries you have a time delay, in many countries you have a time delay procedure, that you lay the bill but you can't proceed on the bill until 90 days or 180 days has elapsed. That is to allow the society an opportunity to have discussion and debate on what is being proposed. And then in some other countries you may have a post-parliamentary referendum, that after it is time delayed and passed by a special majority, then you must take it to a referendum of the population and seek to have the population to bless or not bless what Parliament has agreed. So all of that is designed, those entrenchment methods, to bring protection to the process of constitutional change and to bring some kind of level of consensus that will calm the fears. If you see someone who is normally opposed to a government or what have you coming out and saying, no, well, I think this is a good measure and we should have it, that often lowers the temperature of the level of anxiety. And if you get steep opposition and open political warfare, the tension is obviously going to be much higher in respect of the constitutional changes.
Then I want to go back to referring to me to conventions. And I reflected on the conventions of the rights of the child and how that has been received. And one would think that that would be an easy one to implement. But they all have certain, as Dr. Ghani said, there's always a tug and war. And so, for example, parents see some of their quote-unquote powers going away and so on. From those who believe in the Convention on the Rights of the Child, you see that necessity for parents and and societies and entities to respect that a child is a human being, is entitled to basic things like food, shelter, education, and so on. And as you go globally, that differs, even for people who have signed on to the Convention on the Rights of the Child. So, you know, it really makes you see different perspectives, and even though that should not, one would think, be a political one, there are developed countries that have not signed on to that convention for years. But I will say Belize did.
And was
with pride,
which we can always be proud of.
Exactly.
The issue of conventions, though, I think is one that is very important. And while when we talk about human rights and the Constitution, there are some very strong overlaps. However, the association isn't always clearly made. Is there a general hesitation to be able to embrace the concept of human rights because it's not necessarily from within our own territory? We can understand that our laws are Belizean laws and they have been maintained over the course of time, closely linked to the Magna Carta, and so are human rights. However, there seems to be a very clear distinction that the human rights are from another entity and the constitutional laws are ours.
Well, I think what has happened is that the human rights have worked their way into the Constitution. Now, in the British system, there is no written document, there is no written Constitution. So that this is where you talk about a Westminster model and you talk about a Westminster Whitehall model. And that Westminster Whitehall model is what would apply to us more directly, largely because civil servants in Whitehall in the UK got political instructions from various countries that this is the kind of constitution that we want to have, and we are infusing the human rights into it, so that the issue of a single document representing your constitution that has a Bill of Rights inside of it and has all these other powers, duties, and functions that make up the mosaic of what is going to be handled in your country is different to what obtains in the United Kingdom. So it's not pure Westminster. It's Westminster Whitehall to a large extent, is a terminology that has been used to describe what we have in the Commonwealth Caribbean, because there is no written constitution, there is no Bill of Rights in a constitution, and therefore there's a clear variance away from what is there, so that what we have is perhaps a total package, whereas what you will find in the UK are different packages, but conventions all string around these things to determine the political behavior of the way in which that system will operate. So in the Commonwealth Caribbean, sometimes we have great difficulty operating even a written constitution. Far less if we had an unwritten and we were operating by conventions. It might have been a very different situation.
As I'm listening to you talk about that, even the spirit with which the Magna Carta was originally created, which kind of looked at the divine rights of kings. And when we talk about even constitutional law today, we talk about the rights of the states, the rights of the individuals, and what should be the direction or the balance that is being sought there. Because that always seems to be a part of the conversation, that individual rights can impact severely on the rights of the state to do certain things. So how do you strike that balance and as you move forward in the evolution of the law?
Yeah, well, with your Bill of Rights of the Constitution, there are certain things that the state can and cannot do. And there is a burden to operate within the confines of due process of law. So that in that context, from a political standpoint, the state just can't do what it wishes. There will obviously be challenges that may arise in different arenas. So that it's the kind of thing that you have, one, where the judicial process does bring a tempering hand to the overall operation of the system. And then you also have the rotation of political power. So political power over the period of your independence may have changed hands on more than once, more than twice, what have you. And with that comes another protection in the political system where you have free and fair elections, and that the population will decide which way they want to vote. That's another constraining factor. So you don't have eternal power in one party. You have different swings back and forth. Now, in the American system, after President Roosevelt died in 1945, they moved to amend the Constitution to create term limits for the presidency. So there would be a guaranteed change for a president after 2 4-year terms in office. So you have different ways in which power can be curbed. There is debate going on. Trinidad and Tobago at the moment has a constitution amendment bill that is looking at limiting the term of the office of Prime Minister in office and having the recall of MPs and having runoff elections and so on. That has not been finally determined. But what I'm saying is that constitutions try, in many instances, based on the political instructions that are infused into them, to come up with various techniques for curbing power. So in the case of term limits, you may change a leader by virtue of term limits. In the United States, for example, so Barack Obama cannot now contest any further elections, as was the case with Ronald Reagan, as was the case with Bill Clinton. So it means that someone else will hold that office, and the Constitution has mandated that there should be a change of personnel in that office, so that you have that kind of outlook, and constitutions can be creative enough to do that, and the extent to which that is desired is a function of political consensus within a particular society.
Given the fact that we came to independence later on, and you look at what are, I don't know how you say it in legal terms, but I guess best practices, how the shaping of many of our constitutions, when you talk of the Westminster Whitehall process, that, or I don't know the terms, no, but that shapes what we are doing currently, that we did not do more of a hybrid kind of system to take some of the best practices and build those in, as opposed to having some of the challenges that we have now to actually make some of the changes that perhaps people debate very frequently that would have better served us in terms of our early development.
Well, hybrid systems are always the kinds of systems you have to be very careful how you construct them. A pure Westminster type model is based on the fact that the executive will dominate the parliament and the executive comes out of parliament. A pure Washington's type executive presidency model, the president and the legislature are completely separate and are elected separately. So the hybrid model is a little bit of like what you may have in Guyana at the moment, where there's an executive president who can face a motion of no confidence in parliament, but who also can prorogue or dissolve parliament, as the case may be. So as is what is happening now in Guyana, you have a situation where the president prorogued parliament in November last year, and now has come to a point where the time for that prorogation is going to run out, and with no collaboration with the opposition, the choice is that you will just have to go for a dissolution. But Guyana has that's the hybrid model. So they've tried to keep some elements of parliamentary while bringing in some elements of presidential. And when you make that cocktail, sometimes it can be a lethal cocktail, depending on how the hybrid was constructed. If you keep it separate, you may have elements of one and elements of the other, but where the construction of power and the engagement between the legislature and the executive is not part of what you're dealing with. You deal with other things like your court system and various other things that go outside of that basic construct of power. Then you don't have the kind of hybrid that sometimes people are looking for. I think it's a great thing. Yeah, we should have, bring in this kind of thing. And when you come to the reality of the politics, it's another story altogether. So you have to be very careful. And the society too. What's the nature of your society? Kind of population you have, the kind of culture, the kind of backgrounds, beliefs, and things that have evolved over time. One has to be conscious of the nature of your society, which may be very different from some other societies who are attempting to have hybrids.
Now, you've had the experience of moving around the Caribbean so far with a couple of these lectures. What has been the feedback?
Well, the feedback has been quite interesting. In Dominica, we had a retired judge who gave a lecture, and there were a number of persons from Dominica State College and some UE students, and also sixth form students. So that it was a pretty good lecture in the sense that a lot of people did not know about Magna Carta, so they got the awareness. And then we went to St. Vincent and the Grenadines. We had a former Attorney General of St. Vincent and the Grenadines give the lecture. It was not one with schools, but was an evening lecture on a Saturday afternoon that had a public advertisement of the event, and people came, and there was a nice question and answer session after the lecture was given. Again, a lot of people not being aware of Magna Carta, the consciousness of it was awakened, and we had a very nice engagement. So those are two different models of engagement. So the engagement in Belize now is to deal with the junior colleges and that kind of thing. So it'll be interesting to see the discussion here. In Dominica, there was a panel discussion after the lecture. In St. Vincent and Grenadines, there was not. It was a different type of engagement. Here, there will be a panel discussion after the lecture is given. So it's generating the kind of awareness that really what the promoters, the Magna Carta 800th Anniversary Committee, would have liked.
Yeah. What has been the most common question you've heard so far?
What is the Magna Carta?
Even after your presentation?
Oh, no, before, going into it. No, after the presentation, then people became particularly intrigued by these principles, and now were able to make a connection between things that they have taken for granted and now finding out where this has come from in many instances.
It's interesting because it kind of dates you sometimes when the conversation starts, that you find that maybe some of us who are a little bit more mature, right away you remember that history lesson or that literature class or something. And it was interesting that last night when we were putting the program together, a couple of my younger staff members were able to say, we did do a class on blah blah. So at least they've heard the term, and now it makes you reflect on what exactly was that and what is it all about. So it's a good conversation, I think, that needs to happen, and then you try to again see how this has evolved over history and how it affects where we are today.
Your presentation itself, is it focused more on just being able to explain what the Magna Carta was, especially understanding your target audience here in Belize are going to be late teens?
Well, I am not doing a presentation as such to the extent that there is a featured speaker and there's a panel discussion, so that they will be able to localize the discussion, so that there is a general corpus of work that has been done on the Magna Carta over the centuries, but the local discussants will be the ones who perhaps can have a more general discussion about influence in the local environment, and that's going to be the value of the discussion, where we are bringing what is a very well-known historical document and its contents into a local setting and try to make connections with the local environment through that debate that
and in putting together the speakers, that was the whole idea, is to Belizeanize this for the relevance. Cite cases, for example, where human rights was clearly an issue, and those kind of things, so that the connection can be made.
Now, Dr. Ghani, you said something earlier, and Ms. Bennett did bring it back just now, the localizing of this Magna Carta influence, so to speak. Why is that such a critical thing? Because if we're talking about human rights, and it has been postulated that human rights are human rights wherever you go in the world, but then we're still kind of intimating that there are nuances based on the society in which you live. Why is that the case, and why is that such an important consideration?
Well, I think that because of the 800th anniversary of the Magna Carta, it is now going to be on parade and being brought out from the shelves where it has been quietly hidden for some time. In 1915, there was a 700th anniversary committee established in the UK, and there was a publication that was put out, which we're also going to do, put out a publication. So it will leave a legacy of something. But in 1915, there was no Commonwealth Caribbean. We were the British West Indies, and therefore in that colonial imperial environment, there wasn't that level of debate that could take place in many of our territories. But in 2015, we certainly are very much present, alive, and around. So that is one of the things. The other thing is, Sir Robert Worcester did tell me that in making arrangements to have Her Majesty the Queen become patron of their 800th anniversary committee, he told me that Her Majesty had told him to please ensure that you do not forget the Commonwealth. And that, I think, is one of the things that has driven this process to open it up throughout the Commonwealth in terms of offering these research grants, and not to view it purely as a UK phenomenon, but to open it up in the Commonwealth, and therefore by offering research grants and so on to be bid on from the Commonwealth and other parts, we're able now to bring this forward and have it put front and center during this period of celebration leading up to June 15th.
Now, and I asked that question, and in your response, the whole idea of the Privy Council, for example, is one that people think about. And when you think about these kinds of laws and their genesis within England or London, and how that actually trickles down into, and then there's this, we became independent, we want to divorce from certain things that are, you know, based or ties that tie us to that colonial history. How do you get people to understand that connection that still remains, and even though we may choose to want a certain divorce, that it is perhaps built into what we do, at least in terms of philosophy?
Well, the legal principles will not be part of the divorce. The divorce will be the institution. So that I know that you had your 9th Amendment and you had other amendments. There was other amendments that, and you've now adopted the CCJ as your final court of appeal. So there are 3 countries in the Commonwealth Caribbean that have done it. Now, St. Vincent and the Grenadines, in their draft constitution in 2009, had included CCJ as part of the process, and becoming a republic and having an integrity commission and all these things was put to the electorate in a vote as mandated by the constitution. There had to be a referendum in which you had to get a 2/3 majority vote of the electorate, and it did not get that, so the bill did not become law. So the population decided that they did not want a CCJ. So because of the referendum, you have some of these realities sometimes that may happen. Trinidad and Tobago put forward a position of wanting to go to the criminal side of the appeals but retain the civil for the Privy Council, and that was not accepted regionally in terms of some of the institutional realities about that. There is talk in Dominica and in St. Lucia of making the change, and Jamaica is going to take a position later this year. So that institutionally you can set up whatever institution you want, keep the Privy Council or adopt the CCJ, but the principles are the critical things that judges may still uphold or will still uphold, because those principles have not disappeared, and those principles have stood the test of time in terms of their value in establishing the rule of law and establishing all of these other principles that do form part of the legal process.
Well, let's get the details about today's event.
Okay, so in just about 45 minutes, at 8:30, our students, and by the way, some of them are not young people. We have adult learners. I'm speaking for my adult learners here. And so we should have a mix in terms of age group. And some faculty members, lecturers would be there as well. And so they will be gathering at the UWI premises right around the corner on Princess Margaret Drive to hear the distinguished lecture being delivered again by Mr. Richard Dickey Bradley, and then our other distinguished panel members, Mr. Michael Young, Ms. Cynthia Pitts, Mr. Joseph Sampson, and then there will be 2 opportunities for question and answer. So it should be quite a nice, informative gathering. And again, I think it would be very gratifying if out of this you hear debates happening within the classrooms and in other places where the Magna Carta now would have some currency, would have some value, because people would understand how it has shaped where we are today. So I'm really hoping that comes out of it, and this is really just the beginning of that conversation.
One final thing, Dr. Guinea. The whole idea of a bottom-up approach in terms of shaping law, is that what this actually promotes as well?
Well, it's not intended to be a bottom-up approach to shaping law as much as it is intended to disseminate awareness about the Magna Carta and its principles and its connections to some of the institutional or constitutional arrangements that you have in the various countries in the Commonwealth Caribbean. What you are asking about could be a possible byproduct of the process in terms of people now having a greater awareness about some of these things and wanting to talk a little more about the broader philosophy of what they have in their constitutions and so on.
All right. And final point to the public, why is it important that people understand what the Magna Carta is?
Well, there's nothing like being empowered by raising your level of consciousness, not just taking for granted the institutions and the constitutions and the principles that you have in your local environment, but rather trying to understand where this has come from and how did we get this. And I think that is the value that this discussion can bring to the table.
And I just want to finally say that what I also hope will come out of this for the wider population is that understanding of what's in it for me, the WIFM as we call it, in terms of these are my rights and I should know what my rights are, and therefore when there's a situation in my life, I can't always afford an attorney, but I do know I have a right. Yeah. And I think that if nothing else would be achieved from this kind of conversation.
Well, we want to thank you both for joining us this morning, and we wish you the best.
Thank you.
With this undertaking, and definitely we hope that some eye-opening moments will happen here in Belize for you.
Thank you very much, Marlene.
Thank you very much. Thank you.
We're going to go ahead and take a break, and when we come back, we'll be talking to Dr. Fernando Cuellar about hepatitis A, so stay tuned.